Thank you, Mr. Speaker. I want to talk for just a moment as colleagues, not as Republicans or Democrats, not as members of the majority or the minority, but colleagues who are blessed to serve in the United States House of Representatives, the People's House, with all the tradition, with all the history, with all the laws that have been passed, with all the lives that have been impacted. I want us to talk as colleagues, because our foundational document gave us, as the House, unique powers and responsibilities. We run every 2 years because they intended for us to be closest to the people. The President was given different duties and powers. The President was given the duty to take care that the laws be faithfully executed. So my question, Mr. Speaker, is what does that mean to you, that the laws be faithfully executed? If a bill becomes law and there is no question with respect to its constitutionality, does the chief executive have to enforce that law?
Have to enforce it?
Yes.
The president has a constitutional responsibility to enforce the laws. And the executive branch has the responsibility of enforcing the laws.
Right. So you agree with me that if a bill passes and is signed into law and there's no allegation of a lack of constitutionality, the chief executive has to enforce that law?
I mean, we're talking about a hypothetical situation here now, and given the hypothetical that you have espoused, I would think that there would obviously be a responsibility to enforce the law.
We know the president can veto a bill for any reason or no reason. We know the president can refuse to defend the constitutionality of a statute, even one that he signs into law. We know the president can issue pardons for violations of the very laws that we pass. And we know that the president has prosecutorial discretion as evidenced and used through his U.S. attorneys. Mr. Speaker, that is a lot of power. What are we to do when that amount of power is not enough? What are we to do when this president or any president decides to selectively enforce a portion of a law and ignore other portions of that law? What do we do, Mr. Speaker, regardless of motivation, when a president nullifies our vote by failing to faithfully execute the law? I want to ask you this. You issued a memo directing in certain circumstances that your AUSAs and USAs not inform the grand jury and therefore not inform the jury and therefore not inform the judge about drug amounts.
About drug
amounts in Title 21 cases.
I'm sorry, drug
amounts.
Drug amounts, I'm sorry, go ahead.
Right, it's a memo. In cases involving Title 21 mandatory minimum sentences based on drug type, prosecutors should decline to charge the quantity necessary to trigger mandatory minimum. General Holder, we already have a safety valve. Congress has already passed a law that if you meet these requirements, the mandatory minimum is not applicable. So why would you eschew what Congress has done and trump it with a memo? Well, I mean, I'm really honestly trying to understand how you can respect the law and disrespect a statute that Congress has already passed.
Well, ultimately, I'm trying to do is to push discretion in the hands of the men and women who serve as assistant U.S. attorneys to look at the defendant who is in front of them and make an appropriate determination based on the conduct of that person what an appropriate sentence is.
How do we explain waivers and exemptions and delays in a bill passed by Congress and affirmed by the United States Supreme Court? How do we explain away a refusal to enforce mandatory minimums that were passed by Congress and affirmed by the Supreme Court? And why pursue, Mr. Speaker, immigration reform if presidents can turn off the very provisions that we passed? You know, in the oath that brand new citizens take, it contains 6 different references to the law. If it's good enough for us to ask brand new citizens to affirm their devotion to the law, is it too much to ask that the president do the same? If a president, Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that in some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecutorial discretion. Wherever the line is drawn, it's got to be drawn somewhere from here. It can't include categorical rejections of the application of the law to millions of people.
If a president can change some laws, can he change all laws? Can he change election laws? Can he change discrimination laws? Are there any laws under your theory that he actually has to enforce? What is our recourse, Mr. Speaker? What is our remedy? Some would argue the framers gave us the power of the purse and the power of impeachment, but Mr. Speaker, those are punishments, those are not remedies. What is the remedy if we want the executive to enforce our work?
But I would just tell you that I always thought prosecutorial discretion was an individual prosecutor determining whether she or he has enough facts to substantially result in a conviction on a case-by-case basis. If a president is ignoring entire categories of the law, whether it be immigration, marijuana, mandatory minimum, the ACA, what is the remedy for the legislative branch?
Well, first of all, the first part of that question is, as you may know, I do criminal defense work. I would never go to a prosecutor and say, I want your prosecutorial discretion to say that the entire class of which my client belongs cannot be subject to this law, because prosecutors would look at me and say, are you insane? I am not Congress. So I wouldn't even raise the question. Now, in terms of where we go from here, I'm not too sure, because the great concern I have for this body is that it's not only being circumvented, but it is also being denied the ability to enforce its inherent powers. Many of these questions are not close in my view. The president is outside the line. But it has to go in front of a court, and that court has to grant review. And that's where we have the most serious constitutional crisis I view in my lifetime. And that is, this body is becoming less and less relevant.
Mr. Speaker, we are not held in high public esteem right now. Maybe members of Congress would be respected more if we respected ourselves enough to require that when we pass something, it be treated as law. Maybe we would be more respected if we had a firmly rooted expectation that when we pass something as law, it be treated as law. Maybe we would be more respected if we put down party labels and a desire to keep or retain or acquire gavels and picked up the history, the tradition, and the honor of this, the people's house. Mr. Speaker, the House of Representatives does not exist to pass suggestions. We do not exist to pass ideas. We make law. And while you are free to stand and clap when any president comes into this hallowed chamber and promises to do it with or without you, I will never stand and clap when any president, no matter whether he's your party or mine, promises to make us a constitutional anomaly and an afterthought. We make law. Nell Lindsay was a nurse at a local hospital. Her shift had ended and it was time to go home. She couldn't take her own car because her husband had disabled the car so it wouldn't work. This is the same husband who had broken her jaw on a family vacation. The same husband who had knocked out her teeth in an Applebee's parking lot while her children watched. The same husband who had called their oldest son a sexual orientation epithet and put beer in the baby bottle of their youngest child. So Nell Lindsay got a ride home from the hospital from work with a friend of hers. And as they were headed home, they saw an ominous sight, Madam Chairwoman. They saw the car of her estranged husband. Now, he had been ordered to stay away from her, Madam Chairwoman, but he didn't care. And there was a condition of bond to stay away from her, but he didn't care. And there was a court order, an order of protection to stay away from her, but he didn't care. And when Nell Lindsay and her friend saw that ominous sight of Marion Lindsay in a car, they did a very smart thing, Madam Chairwoman. They headed straight for the Inman Police Department. And they're jumping over railroad tracks, and they're running stop signs, and they're running red lights. And Nell gets out her cell phone, and she calls 911. And she says, "Please help. Please help." So they pull into the back parking lot of the Inman Police Department, and she still has the cell phone to her ear. And through the audio tape that we played at trial, Madam Chairwoman, you could hear Nell Lindsay saying, "Please help. Please help." And then you heard 4 gunshots. And when they took her body out of the back seat of that car, she still had the cell phone in her hand. The system failed Nell Lindsay, Madam Chairwoman. She did everything we tell battered and abused women to do. The courts couldn't save her. The prosecutors couldn't save her. Her husband's on death row, but that doesn't save her. But even in her death, Madam Chairwoman, she did something good, because she spawned changes in South Carolina in the way that we treat violence against women. And with the help of Violence Against Women grants, like the ones that are at jeopardy today, with the help of those grants, and a woman named Lynn Hawkins, who I must concede, Madam Chairwoman, does not share my political ideology in any way, shape, or form. But she put the political sloganeering and the bumper stickers behind. And she said, "Let's change the system in South Carolina," and we did it. And it wasn't in time to save Nell Lindsay, but it was in time to save a graveyard full of other women in our state. So I'm going to ask simply this, Madam Chairwoman. Can we stop the election year gimmicks? Can we stop these manufactured wars that pit one group of Americans against another group of Americans? I spent 16 years prosecuting men who raped, stabbed, strangled, shot, and killed women. I have a mother, a wife, a daughter, 3 sisters, and the images of countless women indelibly imprinted on my mind because they were killed by men who claimed to care about them. This is not about politics to me, and I will not yield. I will not yield. If you want to make women safer, then change the way we draw juries, change the discovery rules, improve the rape shield statute. But stop focusing on November's election for just one afternoon and wonder with me what good we can accomplish if we will stop the political games and if we could pick up some humanity and embrace the fact that even in a political environment as dysfunctional as this one, we can find common ground when it comes to fighting for those who have no voice, who have nobody to stand up for them.
Thank you, Mr. Chairman. Mr. Holder, Assistant Attorney General Ronald Weitz wrote a letter to a member of Congress February 2011, a letter which was demonstrably false. Your department withdrew that letter 10 months later. When did you learn that that letter was false?
Well, I would not characterize the letter as false. I'd say it contained inaccuracies.
Well, Mr. Attorney General, it contained material, demonstrably false statements. Agreed?
I would say that it was inaccurate.
What consequences can we expect because of false statements made to Congress?
Well, as I said, there is an Inspector General investigation that is underway. I'll look at the results of that investigation, but I'll also be looking to see what happened with regard to the creation of that letter, if there's any more information that I can glean on my own before making determinations as to how people will be held accountable for the mistakes that they made.
Mr. Attorney General, it just seems to me that the policy is now going to be, let's get the least knowledgeable person that we can to write the letter. I found the exchange between you and Chairman Sensenbrenner to be interesting on mens rea. The defense is that Mr. Weich didn't know what he didn't know, so we're going to get the least knowledgeable person in the Department of Justice to write the letters to members of Congress. Is that what we can expect from now on?
No, what you could expect from this Department of Justice, as long as I'm the Attorney General, is that we will do our best to get you accurate information as quickly as we can.
Well, what I'm trying to get at, your defense of your friend Lanny Brewer, I guess at some level is admirable. I just don't understand it. It took me a minute to get you to admit that he knew that guns were being walked, and there are scores of emails where he admitted it. He assigned a prosecutor to Fast and Furious. This is someone who on his own website boasts of being one of the best 100 lawyers in America. He knew that guns were being walked. He assigned a prosecutor to Fast and Furious. He forwarded an email to his home computer of a draft of Mr. Weich's letter. And he's going to stick around, Mr. Attorney General?
Well, you're saying things here, see, but you're doing what I asked you to not do before, and that is conflating things. I said he knew about, and he admitted that he knew about gun walking when it came to Operation Wide Receipt. But
Mr. Holder, the letter is very specific. ATF makes every effort to interdict weapons that have been purchased illegally and prevent their transportation to Mexico. Is that true or false?
That is not accurate, but Mr. Brewer didn't, as he indicated, he said he did not have anything to do with the creation.
He forwarded this letter, a draft of it, to his home computer. Now, it does not take a long walk to get that he forwarded it to his home computer to read it.
I'm only going by what Mr. Brewer has testified to, which is that he did not think that he reviewed the drafts before they went out.
Who is Daniel Mudd?
He was the CEO of Fannie Mae during this period.
What was his total compensation?
I don't know off the top of my head, sir.
So you wouldn't disagree if it were $12 million?
That could be right.
How about Richard Siren?
He was the CEO of Freddie Mac.
During what time period?
I'm not sure, but it ended at the time of conservatorship.
Exactly, 2003 to 2008. Now, what was his total compensation for that time period?
Again, I'm sorry, sir, I don't know that.
Would you disagree with me if I told you it was more than $38 million?
I could believe that.
All right, so surely you can understand the frustration of taxpayers who are paying bonuses while the bus is driven through the gates of hell, right, and then you want us to pay bonuses while the people change the tires. Who was James Johnson?
James Johnson was the CEO of Fannie Mae prior to back in the 1990s.
And what was his total compensation during that time period?
It was substantial, sir. I don't know.
$100 million.
Right.
Now, he had a good working relationship with Congress, right?
Yes, he did.
Okay. Now, Franklin Raines, what was his total compensation?
I don't know, sir.
Would you disagree if it were more than $90 million? Then he had a good working relationship with Congress. So sitting here simply saying that we need a better working relationship with Congress, one could argue that's what got us into this abyss.
I'm sorry, I don't recall saying having a better working relationship with Congress. I thought I said...
I've heard you mention the word Congress a half dozen times. And Mr. Chairman, if I could have 30 more seconds, the graveyard is full of people who are waiting on federal judgeships that never came. And I've heard the argument time and time again that we have to raise compensation levels for federal judges so we can attract the right kind of people. And yet every time there's an opening, there are 100 folks that are dying for it. They'll take a tremendous cut in pay. Now, I find it bitterly ironic that the total compensation for the United States Supreme Court justices is less than either of these two men made.
So here we are again, Mr. Speaker, less than 6 months removed from last summer's so-called debt crisis, on the verge of committing another act of generational embezzlement, we are on the verge of assigning another $1 trillion of debt to our progeny because we can't muster the courage to make hard decisions. We're on the verge of $16 trillion in debt, Mr. Speaker, because we can't bring ourselves to say no. We're on the verge of $16 trillion in debt, Mr. Speaker, because we refuse to have a serious conversation about the role of government juxtaposed with the role of the individual. And in times like this, when leadership and moral courage, as my friend from South Carolina, Mick Mulvaney, so eloquently put it, when moral courage and leadership are needed, we get slogans more befitting of a student body president race than a campaign to be the leader of the free world. This administration says it wants a balanced approach, but a balanced approach apparently doesn't include a balanced budget. This administration says it wants a grand bargain, a big transformative deal, but the details of such a deal would fit nicely on the backside of a postage stamp. And my personal favorite, Mr. Speaker, this administration wants the, quote, rich to pay their fair share. I've heard that phrase several times this morning. What I have not heard, Mr. Speaker, because they never seem to get around to defining who the rich are, and they never seem to get around to defining the word fair, which may be the most subjective word in the English language. So I would ask, is it fair? Is 34% not enough? Do you want a half? You want 2/3?
Gentleman, yield for an answer.
Will your president define who the rich are?
Will the gentleman yield for an answer?
And what's fair?
I'll be happy to answer the gentleman if the gentleman will yield. Will the gentleman yield?
The gentleman from South Carolina controls the time.
I didn't hear the answer. Will the gentleman yield?
The gentleman from Colorado will suspend. The gentleman from South Carolina may continue.
Thank you, Mr. Speaker. I hope the generations that come after us will have the courage the generations that came before us had, for we have been profiles in timidity and greed.
I think that the American people should know that the members of Congress are underpaid. A lot of members can't even afford to live decently when they have their job in Washington.
So what is your thought about a pay raise for Congress? And this is if I make a lot of friends on either side of the aisle, I'm sure, with your answer, whatever it may be.
You know, Greta, I know a lot of people in the world that are underpaid. In fact, I live with one who's a school teacher. But members of Congress are incredibly blessed and fortunate to have the jobs that we have. Nobody makes us run. Every 2 years, we offer for public office, and if you don't want to do it, then don't run. But the notion that you can make $174,000 in this country and be underpaid is laughable. We are better off than 99.9% of the people that we claim to work for, and I would be embarrassed to say that given our job performance and our salary, that we are anything other than grossly overcompensated. Public service means you give something up. You get compensation in other ways. You get the benefit of working in the Capitol, of being part of history, of being able to vote for your fellow citizens, all of which is priceless. So even if we were doing a great job, which no one believes, including our families and staffs, believe we are, we still don't deserve a raise. Because there are equally important jobs like law enforcement and firefighters and education and anyone who takes care of children who make far less. My wife makes a fifth what I make. My sheriff makes less than half of what I make. And they do a great job. So $174,000 is a lot of money, Greta, whether you're doing a great job or not so great a job. And look, there are members of Congress that I think earn their salary. I think, you know, Jason Chaffetz, I'm a huge fan of his, Jimmy Jordan, Paul Ryan. There are lots of people that are in politics for exactly the right reason, but every one of them knows that you're going to give something up. If you think you can make more money in the private sector, then don't run for office. If you think you can make more money practicing law, then practice law. But don't run for office and then complain about the salary, because you know what it is when you file. And I'll say this to the witnesses. I prepared a list of questions for all three of you. But during the ranking member's opening statements I shared with him on the floor, my mind went away from the questions and I went back to South Carolina. In the very same month, the very same year that the IRS was conferencing in Anaheim, we were furloughing law enforcement officers. We were furloughing teachers. Prosecutors in my own office were furloughed. Secretaries in my own office were furloughed. Those are secretaries who struggle to make ends meet under the best of circumstances. And here we're asking them to go 2 weeks without pay, and we canceled all out-of-town training. We brought our own food to our Thanksgiving and Christmas office socials. We started an anonymous fund to help our fellow employees who were struggling to make ends meet. And one night, one of my secretaries came in after hours and asked if she could borrow the money to buy her child a birthday present. And she kept apologizing for having to do it. She kept saying, "I'll pay you back. I'll pay you back." And at exactly the same time, that young government employee, single mom, was borrowing money for a child's birthday present, other government employees were staying in $3,500 a night rooms. Other government employees were spending more money on promotional materials than that young woman makes in a year. And other government employees were spending more money on audience participation tools than that young woman makes in a year. So, Mr. Inspector General, I appreciate the work that you've done, but with all due respect, this is not a training issue. This cannot be solved with another webinar. This can't be solved with just one more recommendation. If we can just get that recommendation implemented, we're just one recommendation away from people acting responsibly. Mr. Inspector General, we can adopt all the recommendations you can possibly conceive of. I'll just say it strikes me, and maybe it's just me, but it strikes me as a cultural, systemic, character, moral issue. The IRS has been in existence, depending on how you want to count, either since 1862 or 1918. But in either event, they've had 100 years to figure out that while your fellow Americans are losing their jobs and their health insurance and their homes, you do not spend $4 million at a conference for which there is no accountability. You do not hire people to make meaningless speeches or artists to paint paintings of Bono. When your fellow citizens, the ones who pay your salary, are struggling, that is a character issue. Training cannot fix that. They sent more than 25 employees on a scouting trip to see whether or not the hotel was okay. That's not going to be fixed with training, Mr. Inspector General. When you got law enforcement officers being furloughed and you've had 100 years to figure out how to act appropriately, you don't need an IG report to tell you that spending $27,000 for someone to talk about how random combinations of ideas can drive radical innovations, there's not a webinar in the world that's going to fix that. So, Mr. Inspector General, in reality, it just strikes me that we just need one single recommendation. Start over. This entity has not only targeted citizens that it was supposed to serve, it's allowed itself to be used as a political tool. Not only does it have access to our financial information, it will soon have access to our health information. Those are details that we don't share with people that we do trust. And we're going to be asked to share it with people who are so disconnected as to spend this amount of money while our fellow citizens are struggling mightily in the fall of 2010. I don't think training is going to fix it. I think replacement might. Utah. Mr. Chairman, you have an absolute right to remain silent. No inference or suggestion of guilt may be inferred from your invocation of that right to remain silent. However, if you do testify or take the stand, you will be treated like any other witness and subject to cross-examination. Mr. Chairman, the reason that phrase is running through my mind is because I heard it for 16 years. It's being repeated in courtrooms all across this country today, but not for powerful people that work for government, just for everyday folks. Just for everyday witnesses or everyday defendants of petty crimes, not charged with violation of constitutional rights, maybe just petty larceny. But they're being told you have a right to remain silent. However, if you testify or take the stand, you will be treated like every other witness. Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite, 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not. Mr. Chairman, she testified, I have done nothing wrong, I've broken no laws, or broken no IRS rules or regulations. That's her testimony. What I'm saying is we should have the right to cross-examine her on that testimony. Because I'd like to ask her, when you said we need a plan, who is we and what plan are you referring to? When she said we need to be careful that it's not perceived as political, who is we and what are you concerned about the perception of politics for? What are you fearful of, Ms. Lerner? She said, I think we really need to do a project. Again, Ms. Lerner, who is we and what project are you referring to? That is a legitimate question. And every brother and sister at the bar on the other side of the aisle would ask that question on cross-examination if given the opportunity. Can you imagine, Mr. Chairman, can you imagine a fact pattern where somebody takes the stand and says, I didn't rob the bank, but I'm not going to answer why my fingerprints are on the demand note, and I'm not going to tell you why I'm on the surveillance footage with the gun in my hand, and I'm not going to tell you why the dye pack blew up in my car. I'm just going to tell you I didn't rob the bank. That's not the way our system works. You have to answer the other side's questions. I think these questions are fair. The Tea Party's very dangerous. Dangerous to whom? Who, Ms. Lerner? Who thinks they're dangerous? You? The IRS? Dangerous in what way? We need a vehicle to get back to court. Who is we? Why do you want to get back to court? Could it, heaven forbid, be because you don't like Citizens United? Is that possibly the explanation? Mr. Chairman, she said Cincinnati should not have these cases, but then she turned around and said Cincinnati was to blame. That's an inconsistent statement. Every lawyer on that side of the aisle would ask her to explain that inconsistency. Everyone. So why can't we? If this isn't waiver, then can someone explain to me on the other side what fact pattern constitutes waiver? If you can make 17 separate factual assertions and authenticate a document and say, I have done nothing wrong, which is about as broad as any testimony can possibly get. I've done nothing wrong. I've broken no laws. I've broken no rules or regulations. I mean, honestly, what testimony could be broader than that? So necessarily, our cross-examination should be equally broad, and it would be in a courtroom. How often did you use your personal email, Ms. Lerner? That's a fair question. The Committee on Ways and Means just referred that issue to the Department of Justice. How many times did you use your personal email? When you mused about applying for a job with an organization connected with the president, were you kidding, Ms. Lerner? Or were you serious? We know you were contemplating retirement. Were you really seriously going to work? Mr. Chairman, I know my time is up. I'm just going to say this in conclusion. The same Constitution that allows her the right
if she wants to.